Justice delayed is justice denied. That old legal maxim, first attributed to the British statesman William Gladstone, has been passed down from the 19th century in the form of words printed in ink on paper. Laws are thought of as written on parchment signed with pen and ink and attested to with a stamp or seal. Here is the great irony. The need to have a physical document as the official case record has become one of the great impediments to timely justice. In courthouses all across America, the sheer volume of legal transactions has nearly brought justice to a screeching halt. In the Seattle area, they have solved that problem by creating the electronic court record. It is a remarkable accomplishment not because of the technological advancements, but because of the huge paradigm shift required to accept an electronic form of a document as the legal record. This is how they did it.
This is the remainder of the hard copy case files. People used to fight over these all the time. They all needed to have them at once.
Justice delayed is justice denied, because the reality is that if you just simply rely on a court file or a paper file, the fact is only one person can use it at a time.
Well, people who would need a file, of course, be the parties to a case or somebody doing research, a genealogist, a military researcher. There are all kinds of people who will look in the court file for things.
Many people needed access to the same file at the same time, and we were constantly disappointing our customers.
It was not uncommon, and was in fact very common, that a user, a customer, would come to our office, have driven all the way down here to find out that a file was already checked out.
The first person who requested the file was the one who got it. The second, the third, the fourth, the fifth, none of them did.
If there is another department that is in need of some of the information, then you have to find out who has it.
It could be checked out for several days, if not a couple of weeks.
Where are they in the needs of that particular file? Can you take it apart to deliver it to the other department? Became very cumbersome.
People being disappointed all over the place, coming all the way down here from an attorney's office trying to get access to a file that was already checked out.
We would have to tell that customer that they would just need to come back again. So our customers were routinely frustrated.
In the past, before I got the court file, I had to ask my court clerk to get the file. She had to then go ask the office clerk to get the file, who then asked somebody else to retrieve another file, and then it made its way back. And eventually I'd get it, but probably the hearing was already over.
I can remember as a practicing attorney that we would be assigned to a judge for trial, and this judge would not have previously had any contact with the case. So the first thing the judge would do is say, well, I need to order the court file.
Before, they were spending hours in our office waiting for us to find files, waiting for us to pull the file.
So we would all sit in the room with our client, and we would just wait while they found the court file, brought the court file up, and the judge read the court file, and then we could start.
By having a deputy or a staff person even come up and spend a significant amount of time combing through files to find documents in order to file cases, it slowed down the process, it slowed down the justice process.
People were trying to find workarounds of all sorts to not have to deal with the clerk system.
So as they say, necessity is the mother of invention at times. It had come to a point in the clerk's office where we couldn't keep up with the amount of paper that was being filed with us. We would get almost 8,000 documents a day. And 8,000 documents, if you think of it, is a pile about 6 feet tall. We had to come up with a technology solution to assist them.
And so we started a process that eventually led to our electronic court record, where the electronic record, not the paper, would be the official record. Well, these are the remnants of what was 7,500 square feet of court files that we have gotten rid of most of them since we started scanning in 2000. They all have color coding and barcodes and all of the tricks of the trade for hard copy management, which we used, but was never enough to keep up.
The documents came in, they were filed, they were then sorted and staged for pickup.
And there was 10 stacks of 5 feet high files to put back on the shelf.
staff would work on their documents for the day, and at the end of the day, bring them to the counter where they might have to go to yet another desk.
Trial ends and suddenly the court reporter needs to check spelling and information, and the defense attorney wants to find the documents to send to the appellate court. The judge is writing an order and needs facts from some of those documents.
Several stacks of paper on people's desks being returned at the end of each day and being retrieved at the beginning of each day before a document was fully processed.
Court file might have been misplaced, didn't get to the judge's chambers ahead of time, and the victim said, "I can't keep taking time off work." Now, we can pull up the paperwork. We don't have to worry about physically getting a hard copy.
Judges have information at their fingertips now.
We can print it off. We can get our victims to court totally prepared.
We're giving them easy access, and that's what they want, easy access to their records.
I just found it was much easier to figure out how to set bail and what was going on with cases by having them electronically available.
It's made a huge difference in victim safety.
They can look it up right then, right there. So it's instant information, which is huge in a courtroom. The documents are filed with our clerks, and documents are then picked up and retrieved on an hourly basis. Those documents are routed back to our processing area where they're prepared for scanning. They're basically sorted, prepared, and then they're put through a scanner.
With 8,000 documents coming in each day, they have to be turned into scanned images. First they're batched, and then they're brought to the scanner where staff work them through very carefully to be sure that they capture every page. Then they come to an indexer who has to compare the hard copy against what's on screen and assign it to a workflow so that people can do their work in the system and get the document ready for viewing.
We index them, associating the case number with the image on the screen, and then those are committed into our system.
Okay, the final step to get the document into the case record is done by staff who are data entering into the state mainframe.
They're basically routed electronically to staff that pick up that work from it, mark it as complete when they're done, and then the document's available for people to view.
In the electronic world, there wasn't going to be blue ink so that you could recognize an autograph. All of that thinking had to be changed.
And it took really a change in mindset and a change in culture to think you don't need to touch the paper to really be informed about the case.
Raised seals on a certification.
And it took us a while to get used to not getting up and walking back to the file area to pull a file.
Blue back documents, that's an indication of an official court record.
Customers who would stand on our counter and say, "This cannot be the original record. I want to see the file."
Ribbons even from international documents that were attached that you could then prove was an original document.
We would have to tell them constantly, "This is the original record. This is it."
Instead of having a file that they could put little yellow stickies on to mark their place, to viewing something on a screen and having to find a different mechanism for recording their place and their thoughts. It was quite an adjustment.
We're realizing that this is the new way, that this is going to happen, that the process will work.
There were two pieces of legislation that were key to our project's success. The first one had to do with the authenticity of a document and basically allowing the electronic form of a document to stand as the original, so that when we destroyed the paper version, we were really just destroying kind of our input copy. The second part of that had to do with digital signatures and what could be accepted and would be accepted as the official signature on a court document.
As a judge, I'm very well aware of the fact that people want to see a signature. So for me, I often put an image of my signature on the document electronically. That doesn't mean that I've signed the document. This document is signed when a digital signature is placed on it, and that is the push of a button.
A digital signature is mathematical and very complex, and that's why it works.
I have a particular password. I have a digital signature that has been assigned to me that exclusively belongs to me.
It's beyond most of our capability to mess with it.
In my view, it's much more secure. In the past, people could check out that court file and literally light a match and burn the file, and we would never have any other record available to us.
Initially, the hurdle was money. We knew we could do things better, faster, cheaper. And so we knew that there would be a cost savings, and that was the story to tell our funders. The story to tell our users was we could improve customer service, and we improved it quite a bit. We've set up very isolated steps. So the first step was our core ECR. We knew that with that step, we only had to convince our staff. That would at least get us to a place where we were scanning electronic documents and we would have internal savings. Our next phase, which was connectivity, which basically connected all of our partner agencies. And if that was complete, we would know that they would have savings and they would see the benefits of ECR. The third phase was electronic filing, and so had that not gone forward, we would have still reaped the benefits of the previous phases, but that allowed people to file right from their office and then to view our records online.
As a prosecutor, one of the most important things for us is to have appropriate documentation and evidence to file a case and to pursue a case in court.
Justice delayed is a cost to my client's freedom in the community.
Prosecutors as well as defense attorneys, again, we're vying for the same file at the same time.
The record access that we have now, it's instant. We can get it on our desktops.
We have to have the information at ready access.
We feel that it's a more balanced playing field.
Equal access to the documents by all and in ready accessible fashion helps both sides. It really does.
Behind me, customers are able to view their court records. They're able to pull up their case and look at individual documents. They're able to request copies. They're able to do research to look at the actual document to see what happened in the case. They're able to read the judge's order. They're able to order transcripts of hearings.
You have to learn to pace yourself.
When I joined the court in 1996, I was somewhat amazed to find out that not every judge had a computer. There were many courtrooms that had no screens in it, no computers in it. We've come completely full circle. There's computer terminals, like in this courtroom, in every courtroom in the building.
It's important for me to immediately go into the court file, access that particular document, and review it.
Many of them use daily to access the electronic court record.
I do it routinely all of the time.
In the old days where it was, people were saying, I could never see the shift to the paper file. Now I've had people remark to me, I don't know how we could ever go back to the paper file.
It really is thinking outside the box.
A system, an innovation that every court ought to adopt.
Everyone is better served, not simply the lawyers and the judges and the staff who work in it, but the people who have to litigate their cases in court.
Well done. Thank you, sir. Court in recess? We'll take a recess.
Every judge ought to become comfortable with utilizing the tools that would permit them to access court records electronically.
This was a huge mountain to climb, and we climbed it, and we've been successful more than we ever imagined.
A friend told me that we had moved a great leap forward from the 40s to the 21st century.
Now it's more the case that I have judges asking, commissioners asking, when can you get the rest of those records electronic?